Hit record. All right, everyone. I'm going to welcome everyone to this presentation and remind people that if they would like to attend a national conference, and there's a number of them coming up this year, applications are now open, so we would encourage everyone to apply while they have a chance. Basically, the payment for going to a conference is you get to do a presentation. Now, for those of you who are noticing that I'm doing this alone, Marcel is sick today, so hopefully we'll be having her, hello, join us in a little bit. Join us at another time with a different presentation. I'm going to start. And we'll get going. And if you have any questions, I'm going to ask that you hold it until the end, just because I'm doing three things at once. But I'll be happy to try and get my way through any questions you might have.
Are you recording the presentation, sir?
I am recording the presentation, sir.
We have two people in my office watching it live.
Okay, well, there you go. So for those of you who do not know, Greg has joined us. You can't see him because the big camera isn't working, but you probably will be able to pick him up as he speaks. Okay, so this presentation pulls very heavily from the excellent work of Scott Hutchinson of Heinen Hutchinson, LLP, Toronto. His paper was presented at the 2024 NCLP conference, and it was titled Imaginatively Self-Defense. I also pulled from the paper of Katie Doherty of the Ministry of the Attorney General for Ontario, Toronto, and her paper, also imaginatively named Provocation. Needless to say, while the titles were not particularly imaginative, the material covered is quite excellent. And bluntly, if there's a mistake, it's mine, not theirs. But they were excellent starter points. And I'm going to be directing you to a couple cases throughout, and I can provide that later on. There is no PowerPoint. You get to watch me talking at you. So hopefully that's enjoyable enough. All righty. Starting off pretty simply, the opening line we quite often hear was, I wasn't there. Okay, if I was there, it was self-defense. And if it wasn't self-defense, I was provoked. Sadly, this is not as uncommon a defense strategy as you would think. One of the advantages of being a senior manager is we sit in on all the big case management meetings. And I quite often hear, well, we're going to try and make it that that there's no evidence he was there. But if he was there, it was self-defense. The first thing you have to think about is how that's going to appear to your trier of fact. It's really hard to argue, I wasn't there and I was defending myself. So step one, do not, because remember, any defense that is provided to the jury has to have an air of reality to it. And you undermine your arguments when you give two diametrically opposed defenses. So this is something really that you need to think about before you get to that stage. You need to do some really careful consideration of what is going to be my client's best argument going forward, and what are the gains and losses of those, and make some real decisions right at the beginning. There is nothing wrong with a prove-it defense and then going to something else, as long as you don't open to the jury saying he wasn't there, but if he was there, it was self-defense. That's going to sound weak to a jury. Bear that in mind. We're now going to jump to the second part of that. Presuming you've now got your client in a position where it's clear they were there, self-defense is a relatively common one, and it is a statutory defense. In 2013, Parliament revamped the old and bluntly very confusing self-defense law, which created what is considered to be a radical departure from the old Section 34. Section 34 states a person is not guilty of an offense if they believe A, on reasonable grounds that force is being used against them, or that another person or a threat against them or another person, or that a threat of force is being made against them or another person. B, the act that constitutes the offense is committed for the purpose of defending or protecting themselves or the other person from that use or threat of force. And C, the act committed is reasonable in the circumstances. I'm going to stop there for 1 second and just say the three elements noted are often conceptualized as the catalyst, the motive, and the response. The first two involve consideration of the accused's reasonable perception and subjective intent. The third is conduct focused. Now, when the court is required to consider what is reasonable in the circumstances, we jump to section 34 sub 2. And the court has to consider these, and it's a non-exhaustive list. In determining whether the act committed is reasonable in the circumstances, the court shall consider the relevant circumstances of the person, the other parties, and the act, including, but not limited to, A, nature of the force or threat, B, the extent to which the use of force was imminent and whether there were other means available to respond to the potential use of force, C, the person's role in the incident, D, whether any party to the incident used or threatened to use a weapon, E, the size, age, gender, and physical capabilities of the parties to the incident, F, the nature, duration, and history of any relationship between the parties to that incident, including any prior use or threat of force, and the nature of that force or threat. F.1, any history of interaction or communication between the parties. G, the nature and proportionality of the person's response to the use or threat of force. H, whether the act committed was in response to a use or threat of force that the person knew was lawful. So that's the law. Let's talk about them in pieces. The catalyst. Okay, so remember we broke those down. This is that they believe on reasonable grounds that force is being used or a threat of force. The catalyst considers the accused's state of mind and the perception of the events that led them to act. The subjective belief must be objectively reasonable. This is effectively called a modified objective standard. This means that we look at the behavior from the accused's point of view, including their experiences and their circumstances. But, there's a huge underline here, it will also include an objective review of community standards. This means that the person who honestly believes that there is a threat based on the race of the other party would not be able to claim a reasonable apprehension of force. And just to sort of back that away, a person can have an honest belief that, and I'm pulling something out of the air, so do not take this as anything other than I'm pulling an example out of the air. All Black people are dangerous. They can honestly believe that. They can hold that as the God's honest truth. It ain't gonna fly. Okay? Point blank. The community is not going to accept that. That is not an acceptable belief, even though subjectively that individual truly believes it. And that comes from R versus Kill, kind of an unfortunate name, 2020 Ontario Court of Appeal 151. Factors which may be considered in the catalyst are, and again, this will come back a number of times, the immediacy of the threat is not determinative. So the fact that if somebody comes up with a knife right now, obviously that's immediate. There's a real threat there. The fact that somebody has been assaulted in the past and they are present and being threatening may also be a threat. It doesn't have to be that immediate threat. And you can think of that in a Lavallee sort of situation. Obviously, that burning bed where there's a long history between the parties, and the individual effectively knows the beating is coming. They just don't know when it's going to happen. All circumstances must be considered. A mistake of fact does not remove the defense, as long as the mistake is a reasonable one and based on what the accused believes to be true. So again, going back to that point, I honestly believe that person had a gun, and in fact, they have a stick. If the belief is true, if the belief is reasonable in the circumstances, then the defense may lie. They don't actually have to be objectively at risk. It is not unreasonable for people to make quick decisions, which, in quiet reflection, weren't the best choices. The court has said again and again, we don't require people to do the niceties of doing the cost-benefit analysis of, if I do this, this will happen. If I do this, well, this might happen. The court accepts that people react like frightened people and will act, in many cases, instinctively. As long as the other factors are there, the fact that it was the wrong choice in retrospect does not remove the defense. No one consideration is dispositive of the analysis, one way or the other. Reasonable mistakes of fact and beliefs not capable of normal proof at trial are acceptable as part of the basis for accused apprehension. As an example, we make decisions on half information all the time. That's called life. You walk out of the house, well, for those of you who did walk out of the house this morning, you probably walked out, looked around and went, there's not a lot of snow. It's not going to be a bad day. I can make it into work. Or maybe you looked outside and went, I'm not getting anywhere today. I'm staying home. Both are valid decisions. Okay. Both may be correct. Both may be wrong. The point is that it doesn't require that absolute proof beyond a reasonable doubt. It simply requires that you can show that that decision was made and that that belief existed. Let's jump to motive. The accused's actions were undertaken to protect themselves or others from the use or threat of force. The inquiry is subjective. And again, this one actually is taken from R versus Monius, a 2024 decision of the Manitoba King's Bench, 143, a decision of Justice Innes. If you have a defense, if you're going to be running a self-defense case or a provocation, this is the one you want to grab. Justice Innes did an amazing job. This is relatively fresh off the presses. She delivered the decision in October 16th, or on October 16th, and it is an excellent review of the law, and is exceptionally well put together. The court must have some precision around what the motive of the accused was at the time of the specific act. The accused may be partly motivated by a combination of anger and fear, but the fear of harm must be the primary reason why the accused committed the act. So again, it is a self-defense or a defense of other is the primary consideration. Yeah, they can have other things happening. They could be very upset. They could be very angry. There's other emotions that could be happening. But the primary consideration must be self-defense. Vigilantism and vengeance are not protected under Section 34. And again, if you think back to how this act came into effect, how the legislation was changed, remember, this self-defense and provocation were put in, or self-defense was put in primarily to deal with dealing with vengeance killings, okay, and honor killings. That was one of the reasons why this section was amended. So the intention of Parliament when doing this was to remove this concept of injured pride, injured honor, vengeance not being acceptable, vigilantism not being acceptable. The courts will not look fondly upon that argument if you make it. And again, there isn't going to be one dispositive yes/no test here. You're going to have to lay the facts out, and it's going to all be on that modified objective standard. Reasonable response. This examines the reasonableness of the accused's actions on, again, that modified objective test. The examination is focused on a global, holistic assessment of the reasonableness of the accused's otherwise unlawful actions. There is no magic process or formula to what is reasonable. It has to be a flexible approach, which is good from our point of view, because it takes into account the accused's world. What is reasonable for someone in North End, Winnipeg may be different from what is reasonable on Fifth Avenue Northwest in Dauphin as compared to what might be reasonable on Main Street in Thompson. It ensures that the response of the accused was within the community norms of conduct. What would a reasonable person in comparable circumstances do given the event, not what this accused thought was reasonable without any other comparator. The 9 factors listed are non-exhaustive, but all must be considered by the court. The nature of the threat. The trier of fact will balance the response on the nature of the threat. The more disproportionate the response, the less likely the defense will succeed. The old running joke, he brought a knife to a gunfight. Well, if you bring a gun to a knife fight, you're going to have more of an uphill battle. Conversely, if you showed up with no knife, and you managed to get a hold of one, you've got a good running shot. Imminence. There is no requirement that the accused de-escalate or retreat, and that used to be one of the factors, but it is not a requirement. It does consider indirectly the ability to avoid the threat, but does not make it a requirement. There is no standard that says you could have run away, therefore you do not have the option of self-defense. Again, the court's going to look at all the factors. The role in the incident. The accused's complete actions in the event are relevant. Obviously, an accused cannot engineer a situation to create a self-defense scenario. But at the same time, all of the accused's actions will be considered to determine the reasonableness of the response. So, telling somebody they can either go outside or you're going to beat them up inside does not mean you can then turn around and claim it was self-defense. He came at me outside. You've engineered that scenario, and self-defense won't lie. Conversely, agreeing to go outside to avoid being beaten up inside doesn't remove the scenario. It's still self-defense. The use or threatened use of a weapon. The use of a weapon by one or the other party will radically change the circumstances and will impact the reasonableness of the response. Size, age, gender, physical capabilities. Let's face it, that's kind of self-obvious. The relationship and prior communication of the parties. Pre-existing relationships obviously will flavor the reasonableness of the actions taken to counter the perceived threat. Again, we're just going to go back to the Lavallee type of case. where there is that long-term domestic relationship, where there has been ongoing abuse over years and years and years, that is going to flavor what the individual perceived as the threat. And that will, again, lend as to whether the threat is reasonable or not, whether there is a perceived threat, that sort of thing. The proportionality of the response, unlike, as I said, unlike the old section, disentitled to the defense where massive force was used, this is a factor. Sometimes pulling a gun at a knife fight is totally appropriate. You are not required to limit your response to equal force, okay? But the force, while it doesn't have to be proportional, the less proportional it is, the harder it's going to be for counsel to succeed on this defense. Whether the accused knew the threatened force was lawful. This is an interesting one. So the question arises, if the other person is acting in a lawful manner, it is not a bar, but it is going to be a factor. So where you have a uniformed police officer using reasonable force to stop someone who is engaged in criminal behavior, does that individual, in reacting to that, act in self-defense? It's going to be hard, but it's not an absolute bar. It is not a bar to the defense if the accused knew or ought to have known the apprehended force was itself lawful. That is going to be a factor for the finder of fact to determine. So the judge is going to determine whether or not it's reasonable in the circumstances. Again, case to look at, R versus Hodgson, Hodgson, 2024, Supreme Court of Canada, 25. Paragraph 78 is an excellent starting point, but the case itself is quite excellent for the application of this section. What was really good about that particular case is that it was defense. It started off as a defense of a third party. The accused was not the original party involved in this. And the individual used a sleeper hold. And ultimately, that resulted in the death of the victim. The issue came down to, the case is actually out of, I believe, Nunavut. So it actually came down to discussing, in many ways, the behavior of people in Nunavut and a lot of the community of what happened and community standards plays in the background of the decision. And the Supreme Court, basically what happened was the judge acquitted, the Court of Appeal dumped all over the judge, convicted. Supreme Court came back and actually said, no, she's right, you're wrong, dumps all over the Court of Appeal, which made my heart happy. But what was really interesting was you really saw that this is looking at the entire picture. And when you look at the whole picture, everything that happened that night, the interaction between the parties, was there animus? What was his intent? Was this a reasonable thing? Yeah, we all know sleeper holds are dangerous. And it was his, at the end of the day, he did what he thought was necessary, and it was the wrong choice. That doesn't mean he's guilty. And I think that's sort of when you look at that case, it gives you a solid bit of understanding of really how everything plays together in dealing with the issue of self-defense. Obviously, of course, before self-defense can be put to a jury, the court must find that there is an air of reality to the defense where every element can be established by direct or circumstantial evidence. The onus moves to the Crown to disprove the self-defense argument. that's it on self-defense. So now we're going to jump to Peter Kingsley, who will do the presentation on provocation. Okay, provocation. Provocation is an example of a common law defense which has become codified into a partial defense. And this is very important. Provocation is not a wholesome defense like self-defense. It will not result in an acquittal. It stems back to the 16th century, and according to social context, was always an important part of a potential defense. A section dealing with provocation has existed since the creation of the criminal code in Canada, in part because it was accepted that while punishment for causing the death of another warranted punishment, it did not warrant the punishment of death. And remember, of course, up until relatively recently, murder was punishable by death. And it was accepted that there were times where an individual reacted, death ensued, but it was not one of those things that actually should result in the death of the individual. However, even after the abolition of the death penalty, the section remained, which shows that everybody sort of accepted that, there was a line where it wasn't unreasonable for people to cross over. Mark, absolutely. It is very kind of the criminal law to create some sort of civil contributory negligence. And that's actually a really good way of putting it. The section was amended most recently in 2015. The current section on provocation, 232, states culpable homicide that otherwise would be murder may be reduced to manslaughter if the person who committed it did so in the heat of passion caused by sudden provocation. Conduct of the victim would constitute an indictable offense under this act that is punishable by 5 or more years of imprisonment, and that is of such a nature as to be sufficient to deprive an ordinary person of the power of self-control, is provocation for the purposes of this section. If the accused acted on it on the sudden and before there was time for their passion to cool. For the purpose of the section, the questions whether the conduct of the victim amounted to provocation under subsection 2 and whether the accused was deprived of the power of self-control by the provocation he alleges he received are questions of fact, but no one shall be deemed to have given provocation to another by doing anything he had a legal right to do or by doing anything that the accused incited him to do in order to provide the accused with an excuse for causing death or bodily harm to any human being. Culpable homicide that would be murder is not necessarily manslaughter by reason only that it was committed by a person who was being arrested illegally. But the fact that the illegality of the arrest was known to the accused may be evidence of provocation for the purpose of the section. Of course, murder occurs where the person who causes the death of a human being subjectively means to cause their death or means to cause him bodily harm that he knows is likely to cause his death and is reckless. So in other words, Section 232 gives us the opportunity to, in very certain, very specific circumstances, secure a conviction for manslaughter, even though all the subjective intent has been met and all the tests have been met where a person is otherwise guilty of murder. There are, and again, going back to the seminal case on this one is Tran, which is 2010 Supreme Court of Canada 58. The court outlined both the subjective and objective components with particular attention to the meaning of insult sufficient to deprive the accused of the power of self-control. There are 4 elements to the defense of provocation. Conduct by the victim that triggers or precipitates the accused action. The conduct must, from the accused perspective, occur on the sudden and unexpectedly. The conduct must be sufficiently grave to deprive an ordinary person of the power of self-control, and the conduct must cause the accused to suddenly lose self-control and act before regaining self-control. Again, if there's an air of reality to the defense, then it falls to the prosecution to disprove the application. Where the Crown is able to establish a reasonable doubt to any one of the four elements, the defense fails. The trier of fact determines if the triggering conduct amounts to provocation and whether the accused killed the victim as a result of the provocation. Let's talk about triggers. Prior to 2015, triggering conduct included any wrongful act or insult. In 2015, the amendment was narrowed to any conduct which would amount to an indictable offense punishable by 5 years or more imprisonment. The conduct must be the conduct of the victim. This is very important. Again, let's go back to what was this intended to deal with, honor killings, that sort of thing. If the conduct basically is something where the individual who dies would not be punishable by 5 years or more, provocation is not going to lie. So somebody standing in the middle of the street causing a mischief, and that embarrassingly means I have to look up what the sentencing is for mischief, but I'm trying to think of something relatively low end, or doing something where there is no potential for jail of 5 years or more, is not going to allow somebody to act and say it was provocation. Conduct of the victim and the accused occurring on the sudden and unexpectedly. Temporal component is a key factor. So this applies to both the conduct where, from the accused perspective, the conduct of the victim, also the conduct of the accused. Time is the whole point here. If you have time to walk away, to think about what's happened, to consider your alternatives, and then come back and kill them, you're going to have a hard time arguing provocation. The idea is that there is an offense to the individual and a response, and it is as close to instantaneous as is possible in the circumstances. The act and the response must be sudden. This is from Tripodi, the 1955 SCR case, Pappas, 2013 Supreme Court of Canada case. And therefore, the defense fails, as I said, where the accused's action does not immediately follow the trigger, or if the accused has knowledge of the triggering act. If you know somebody is going to slap you, you can't turn around and say, he slapped me, and I was so shocked I shot him. It's not going to work. This accounts for the purpose of the defense, which was otherwise an law-abiding citizen is put to the breaking point by the actions of the victim. It does not allow you to have a Hatfield and McCoy scenario. The fact that somebody stole your sister and married them 4 years ago does not give you the opportunity to shoot them now. The ordinary person. Provocation is not judged solely from the subjective view of the accused. The law is premised on fostering self-control and nonviolent behavior. Accordingly, provocation is a narrow and restrictive partial defense that is limited to situations where an ordinary person would, rather than could, those words are underlined, have lost self-control. This is a Manitoba Court of Appeal case, R versus ASSI, ASSI, 2023, Manitoba Court of Appeal 2, paragraph 12. It is really important that this be kept in mind. It is where an ordinary person would rather than could. This has been challenged in Alberta in R versus Bird. where the accused was diagnosed with FASD. The trial judge accepted that while FASD would have made it more difficult for the accused to respond in a more measured way to being punched in the face, they rejected that the section violated Section 7 and 15 of the Charter. The appeal was rejected by the Alberta Court of Appeal on the basis that there was no air of reality to the defense of provocation. So it still remains open, but it's important to remember that it is going to have that objective standard applied. While Section 232 and specifically subsection 2 requires the act of the victim to be one which is punishable by a sentence of 5 years or more, has been challenged in the courts. It has not reached the Supreme Court of Canada yet. So again, it still remains open. The Ontario Court of Appeal in R versus Bra, R versus Gibb, and R versus Larocque-LaPlante, which went to the Ontario Court of Appeal in 2024, determined that Section 7 was not violated after looking at the text of the legislation, the historical context, the legislative activity in other jurisdictions, and the parliamentary record. They stated there is no disconnect between the purpose to eliminate as a trigger for provocation conduct by a victim which is not itself serious unlawful conduct and the effect of the amendment. So again, these are matters where, depending upon your fact scenario, you may have a run at the Court of Appeal on charter validity of Section 232 and specifically that part, but you are going to have to find the right case facts. And again, my comments are going to be that for those who would like to review a really good decision, I direct you to R versus Monius, which is the decision of Justice Innes from October of last year, where basically it was Laura Robinson and Kirk Knudsen for the accused, Krista Burkus, Mitchell Lavett for the Crown. The argument was, you can't identify my client. If you can't identify my client, then my client didn't have the intent for murder. And in either case, if you find that it was murder, then it's self-defense or provocation. And what Justice Innes does is very quickly sets out what the evidence is, gives the position of the parties, the general premises of it, and then just goes through it step by step. Did he cause the death? Let's talk about identification. Once you get through that, okay, now we're going to jump to, this was faster when I had it on the computer. If Mr. Monius caused the death, was he acting in lawful self-defense, and goes through it step by step by step. And then determines, if it wasn't in lawful self-defense, was he intoxicated, that he lacked the intention? And if those fail, has the Crown proven that he had the intent for second-degree murder? If that fails, does the standalone defense of provocation reduce the murder to manslaughter? What's nice is she actually does find that he never had the intent, but she actually works through every potential defense step by step by step. And it's a really good example of how to put your case together, to take what may not necessarily be the best fact scenario, but which can be used in front of the right judge to say, okay, here's how we're going to do it. Step 1, I'm arguing this. If you accept this, now let's move on to step 2, step 3, step 4. And it's probably one of the best primers I've seen in regards to working through a self-defense case. I was aiming for about 45 minutes so that I could have 15 minutes of questions. If that was my presentation, if anybody has any questions, I'm happy to deal with it.
What were the facts of the Monius case?
The Monius case actually was a bar fight outside of a bar. And it's basically, and I again, I don't want to, you never want to trivialize people's lives, okay? But in true criminal law fashion and criminal lawyer fashion, I'm now going to do that. We have two individuals, two groups of individuals who are yipping at each other. We have a fair amount of intoxication. We have some video, not some video. It is pretty clear that there is a backwards and forwards exchange going on. There's definitely the victim was calling on the accused and, saying, come on, come on, come on. It is also clear that the accused then ran back to the victim, and things happened. So it's a video case. So again, the facts are really quite solid. Knife. If I remember correctly. The facts are fairly solid on this one, which is really nice because once she sort of finds these are the details that I see that happened, this is where I think it's going to go, and then starts laying out the law piece by piece by piece. It really is just a beautiful job of going through the law, the cases, setting it all out, having it done nicely. You'd never know she was a presenter at the National Criminal Law Program because she literally wrote, she didn't write the paper on this, but this could be the paper on how to mount a self-defense case and how to consider all the decisions. It's exceptionally well thought through. What I really like is the fact that she said, and if you don't agree that he had this, then I find this. So at no point does she actually stop her thought process. She doesn't say, well, I found this, so I'm not going to consider. She actually goes through each step and says, you want to appeal me? Go ahead. This is what I'm finding. I think it's an exceptionally well written, and I think it makes it very solid from the point of view of an accused. They get to see that the judge really listened to everything and really considered everything. So it's a good judgment, and it's relatively easy to read, which is nice, especially for those of us who don't practice much anymore and trying to figure out when judges are using language that doesn't necessarily match up. Any other questions? You may have to come here for that. 1 second, I am going to, can everyone hear Greg? Speak.
Yes, I can hear Greg.
And in doing I'm thinking back to the last big self-defense case I did. Client stabbed his roommate. Fortunately, the roommate survived. It contains such gems as the 911 call that my client makes afterwards, which is also sometimes important to look at in a Section 34 instance. But where the victim is moaning in the background, and my client goes, "Shut up, Glenn, you know you had it coming." Well, he's on the line to 911. Anyhow, my client, who claimed to have an IQ of 160, which makes him the smartest unemployed welder I've ever met. But we went through the defense many, many times. We had a preliminary hearing, and then we're finally in Queen's Bench in front of Justice Kaiser. And I told him what we had to establish, and when I had the victim up there, I did a good job of establishing that the victim actually had been hitting my client with a chain, that he felt some strong animosity towards my client. So all I wanted to do was get my client up there to tell the court what he feared, how he felt. So my client goes up there, and being, of course, a very smart fellow, first questions I ask him, well, you came home, yes, you had a few drinks, yes, and you had a conversation with your roommate. Now, the roommate had already testified that he was upset and such. So I said, well, what was the conversation about? I expected it to be about money and the anger. There's no general banter. And that was it for my case. My client would not did not see what I was trying to prove, even though he'd been involved in their pre-trial discussions many, many times. And a conviction flowed shortly thereafter. But yeah, so always try to get your client to not to just to tell the truth. Let them know what the defense is, and tell them not to overthink it. There you go.
One of the important things also to bear in mind, and Greg commented on this, is that all of the incident is part of self-defense and can be part of provocation. Again, they're going to look at everything. So the 911 call, the behavior of the accused afterwards. If you're going to argue self-defense, you probably don't want your client trying to hide the body. That's going to go to, again, these are hard questions. I'm not saying it's going to knock it out, but it's looking at the entirety of the circumstances. And one of the factors that's really important for counsel, especially nowadays, where we don't get opportunities at preliminary inquiries like we used to, where you don't have that ability to put more of a, well, we don't know exactly what happened because it's not like there's video of the event. The reality is now there are so many video cameras around. It's amazing the amount of video we get on every incident. It's important that we take a hard look at everything and go from there. Don't be afraid to ask the hard questions of your client early on to determine if this is something you're going to run with and if it isn't. And if it's something you're going to run with, make sure that you put it first and foremost. If you've got a jury, don't confuse the jury by putting forward something that is contradictory and then use it in an alternative. They're going to look at that as, well, he's pulling at anything. In some cases, that's fine. In some cases, it may not be, but it's up to you as the professional to pick the defense that is going to be effective to help your client. Remember, it's not your client's choice what defense is used. It is your job. Once your client determines they're pleading not guilty, you're the one in the driver's seat. Okay, absent any other questions, I am going to close this. I have hopefully recorded the event. And so I hope you all got something out of this. If anyone has any questions afterwards, please feel free to send me an email or a text, and take care. For those of you, well, for all of you, be very careful going home tonight, please. I do understand the perimeter is shut down. I don't believe you can go anywhere in Dauphin at this point. That's about all I know road-wise. But please, 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 it is far better to find somewhere to hole up for the night than it is to get yourself into serious trouble trying to get home. Well, I don't want to say stay at work because that just came out wrong too. But yeah, but seriously, do take it easy and be safe. That's the most important part. Take care, all.
That's the result, I guess.